So it is my pleasure to introduce Tiffany Stacy. She is an office managing shareholder of the San Antonio office of Ogletree and Deakins, an international labor and employment law firm. Ms. Stacy graduated summa cum laude from both Texas Tech University and Texas Tech School of Law. She is board certified in labor and employment law by the Texas Board of Legal Specialization and has been recognized as one of the best lawyers in America each year since 2018. Ms. Stacy works with companies of all sizes, providing day-to-day guidance and counsel to defend litigation. Ms. Stacy previously served on the San Antonio Human Resource Management Association Board of Directors from 2015 through 2020, including president in 2019. So we want to thank you again for joining us, and definitely my pleasure to have introduced you, so let's give her a warm welcome.
Thank y'all for, Red Raider? Yeah, I don't encounter too many Red Raiders here. Can y'all hear me okay? Okay. Thank y'all for having me here today. I was actually not the original intended speaker. My partner was going to speak, but she had a baby. So that was a good reason to miss. I guess maybe things happen as they're meant to be, because I struggle with mental illness. I have suffered from depression and anxiety for years. And to make matters worse, I'm going through a divorce. And so this year has been really hard for me. And as I was gathering my thoughts to come here today, I received notice that I won a case before the Fifth Circuit Court of Appeals. Oh, now I'm really loud. Okay. So as I was preparing for the speech today, I received notice I had won a case before the Fifth Circuit Court of Appeals that I argued in June. And I share with you, I nearly did not get on that plane to New Orleans. I was having a panic attack. I was very fearful of going out of town for the first time and leaving my son behind. And I reached out to my internal network of female colleagues, and I said, help. I need help. I need to get on this plane. I have to get there. And so while no one in the firm other than those ladies will ever know what it took for me to get on that plane and to get there and to go do the oral argument, I did it and I won. And I say that not to brag about myself, but to emphasize the importance of finding the resources that you need to be successful, regardless of whatever limitations you may have, because we all have them. And we're lying if we say that we don't. And we can be successful when we have the right environment, when we have good employers, and when we have supportive colleagues and friends that can get us where we need to be. I certainly pale in comparison to the individuals on this screen, but Abraham Lincoln even struggled greatly with depression. All of Jimi Hendrix, Barbara Streisand, Michael Phelps, Jane Pauley, each of them have struggled with mental illness and yet been very successful. Sounds weird to describe Abraham Lincoln as being very successful, but all very impactful individuals that have been able to persevere and to thrive despite whatever personal issues they may have been experiencing at the time. So I think from my own observation of working through COVID-19 and trying to assist our clients in navigating all of those issues, it was extremely stressful. Most of us were managing being working individuals and being parents and educators and all of that stuff. And not surprisingly, I think the number of folks that reported mental illness, having experienced mental illness, increased after COVID-19. In 2021, it was as many as 1 in 5 adults that had experienced some form of mental illness. And candidly, bad workplaces don't help. You know, if you are working long hours, underappreciated, underpaid, all of those things, that does not help. Conversely, when you're able to find employment with a company that embraces the diversity that is brought to the workplace by a mixture of individuals and is supportive of that, people thrive. It's also just and I don't know, if I have some employers in the room or it's largely individuals, but just looking at a dollar and cents perspective, it's extremely costly for all of us in terms of lost productivity when folks are suffering with mental illness and are unable to concentrate, unable to report to work. And so how do we support them to get through that process? The Americans with Disabilities Act, it's weird for me to say that 1990 was 33 years ago, but 33 years ago, the Americans with Disabilities Act became law, and it was the first federal law that provided protections and defined the rights of individuals with disabilities. Now, my focus, of course, is on employment, but ADA is broader than that. It has to do with your access to public facilities and transportation. Is there a ramp? Is there sufficient parking? Can you navigate? That's part of the ADA, but of course, my focus here today is on the employment rights and responsibilities that exist for folks with disabilities. At its most basic principle, the law provides that an employer cannot discriminate against a job applicant, so it applies to job applicants as well, or to employees with regard to hiring, promotion, compensation, certainly termination, because of someone's disability. You have equal rights in the workplace regardless of physical or mental disability. Now, it's important to know that the law only applies to employers that have 15 or more employees. That is most workplaces, but of course, small folks are excluded from coverage under the law. So who is protected? I think when the ADA was enacted and for some time thereafter, we thought of disabilities more in those that we can see. Certainly, there was just egregious issues with those in wheelchairs and otherwise physically disabled that could not access public transportation, that it couldn't get into their workplace. And so initially, I think many people, and maybe still today, tend to think of the ADA as covering those visible disabilities, and they do. But the ADA is so much broader than that, and the focus of my presentation today is on the invisible disabilities, which of course can be back issues, cardiac issues, things like that, but specifically mental health, because there is so much of it, and there's much more recognition, less stigma now to come forward and to say that I suffer from mental illness, and that's okay. You also have protection if you have a record of having a disability. So one example might be a recovering alcoholic. If you are a recovering alcoholic, someone may judge you by the fact that you once were an alcoholic, and you could go off the edge again. Doesn't matter if you've been 5 years sober, 10 years sober. If your employer or a potential employer regards you as having a disability, you have protection. And the broadest category of all, and this was through legislative enactment, an amendment to the ADA in 2008, is if you are regarded as having a disability. Now, to have an actual disability, it has to be something that it's a physical or mental impairment that substantially limits a major life activity. Regarded as having a disability is much broader than that. It doesn't matter if you actually have one or not. It doesn't matter if you have just a short-term medical issue, but your employer regards you as being disabled, then that too is protected under the ADA. I think that was coming to the forefront most recently with COVID. COVID varied for everybody. Was it really? For some people who had long COVID, it may have become a real disability. For others, it was more of a short-term impairment, but if the employer was regarding you as disabled, that was a problem. The other qualification for having protection under the ADA is you do have to be qualified to perform the essential job duties of the job. Now, that could be with or without accommodation, but ultimately you do still have to be qualified for the job to receive those protections. So the invisible disabilities and those that I think are most common in our community today, certainly anxiety disorder is the most common mental illness that is reported amongst adults. PTSD, depression, attention deficit disorder, and also dyslexia, other learning disabilities that might not be obvious if someone were looking at you. The Equal Employment Opportunity is the government agency that is responsible for enforcement and compliance with our anti-discrimination laws, including the Americans with Disabilities Act. And according to the EEOC, certain mental illnesses are just automatically considered disabilities. And you see those listed here, similar to the list that we just looked at, but of course you also see bipolar, autism, schizophrenia. Those are per se disabilities according to the EEOC. So what makes the invisible disability so difficult in the workplace is it's sometimes difficult for others to understand because they can't see it. And, you know, I don't profess to judge someone who has suffered from bipolar disorder because I've not. So I don't really know what it's like. And that's the problem, is that in the workplace, whether it's your supervisor, your peers, unless we've walked in your shoes, we don't really know what it's like. And so it makes it difficult sometimes to relate. You know, if you have an obvious impairment, we can sympathize with how difficult it might be for you to get around. It's harder when it's invisible, and so that relates to a lot of the difficulty at work. I think also there has historically been a stigma associated with mental illness. And for that reason, employees may be hesitant to bring it up. They may be hesitant to share with their employer that they're struggling in some way, that they need assistance. I thought this statistic was interesting, that 26% of folks actually hid their mental illness from their supervisors in the workplace. And then as we'll look at when we talk about the accommodation process and working through that, it can be difficult because you have to get your healthcare providers to help you out and complete paperwork, and it can be a little bit overwhelming. And maybe you think, oh, well, this will pass, you know, I'll be better. It's not worth all the struggle, and then it doesn't pass. And certainly you want to ask for help before it starts impacting your performance or causing other conduct issues that could result in discipline. You want to be proactive in recognizing if you do need help. So the accommodation process. A big component of the ADA is the fact that the employer has a duty to accommodate. And that applies to applicants, job applicants, applies to employees. The exception to that, of course, is if it does pose an undue hardship for the employer. But generally, there is a duty to at least engage in the interactive process to determine if there is a reasonable accommodation that can be made. Now, I would say if you are an employer and you are posting jobs, you should contemplate the possibility that someone looking at the job ad may require accommodation in applying for the job or in interviewing for the job. And a lot of employers will include contact information if an applicant does require some sort of accommodation in the process. And then certainly, as a job applicant, if you think that you may need an accommodation to be successful in either completing the application, submitting to interview, some employers do testing, like skills testing, as part of the application process. If you need that assistance, ask for it. It would be a shame to be disqualified where you may have been successful if you had had the accommodation that you needed. The interactive process is really, the term interactive is purposeful. There are shared roles and responsibilities as between the employer and the employee. It's a two-way street. So yes, the employer has a duty to engage in the interactive process, but only when it's aware of a need. So if you think about invisible disabilities, that's where you as an individual need to be proactive in requesting accommodation, because an employer may not know what's going on. So you need to be proactive in making that request. It doesn't have to be in writing, but I think it's a great idea. There's record that you've requested accommodation. Oftentimes you may know the types of accommodations that would be effective for you. And I've included reference to a website, askjan.org. It's the Job Accommodation Network. But it's really amazing. You can type in any sort of condition, and it suggests a number of accommodations that might work for you. So if you are requesting accommodation and you have an idea of what might be effective, put it out there and say, this is what I think will work for me. Now, it is important to remember, though, and I run into this issue a lot, particularly with the whole telework thing, you don't get your preferred choice, right? So we received a lot of accommodation requests, or I should say our clients received a lot of accommodation requests to work from home, and that was it. And so the employer does have the right to ask the healthcare provider, what about these other accommodations that don't involve working from home? Would these be equally effective? And if the employer, if there are a number of accommodations that would be equally effective, ultimately it is the employer's choice. So I think as individuals, you have to be flexible, because that is part of the interactive process, is being flexible and seeking, okay, will this accommodation work? Give it a try. If it doesn't, then you can raise that concern again. A lot of times we wonder, okay, well, what's the time limit for this? Whether you're an individual that's seeking the accommodation or you're the employer going through the process, how quickly do I have to do this? A typical lawyer answer, it depends. The law expects you to act promptly and to move it along, but it's going to be very dependent upon the type of condition that's at issue. You are getting documentation from your physicians or your healthcare providers, and they are not always the fastest, or the fax didn't go through, or the email didn't go through. So there's a lot of that, and you have to be kind of patient and do what you can to move it along. And likewise, from the employer standpoint, it's something that you have to actively monitor and make sure that you're doing your part. Everyone does their part, and as long as everyone's doing their part, it should reach some sort of conclusion within a reasonable period of time. So just some awareness in terms of what can and cannot be asked, either by the employer or of the employee. Especially with the invisible disabilities, the employer has the right to ask that your healthcare provider complete certain documentation related to the nature of the impairment, looking at the job description and saying, okay, what job duties can they do? What can they not do? Where might they need accommodation? What kind of accommodation should we make? How long do we think we'll need the accommodation? Will the accommodation be effective? And keep in mind, a lot of that is for employee safety as well. We don't ever want to speculate as to what would be good or effective, and we would really look to your healthcare provider to give us that information. And then, of course, from the employee side, there is not a direct line of access between the employer and the healthcare provider. An employer can't just call up the healthcare provider and say, hey, can you complete that paperwork? You, as the individual seeking the accommodation, are really the liaison. You're the one that has a relationship with the healthcare provider and can push that along. Now, there may be instances where you sign an authorization allowing the employer to have that direct contact, but I mean, the healthcare providers, of course, are very resistant to circumventing their patient. So you as an individual patient, you're the one in a good position to push it along and to make sure that you're complying with the deadlines. You know, and an employer will provide you with a date by which to submit the paperwork. Sometimes that's just not happening. The physician is on vacation, maybe you're physically ill, whatever may be the case. Just be proactive in communicating with your employer about, you know, here's the status, here's when I expect to get it. It's only when someone goes dark, kind of goes silent, that we don't know what's going on. And certainly, if you need an extension of time, make that request. Another thing to keep in mind is a lot of times when we get the paperwork back, it's not complete, or we can't read the physician's handwriting, you know, and so the employer has the right to ask follow-up questions to get clarification. That can be an additional time, but again, we want to get it right. And then finally, there is also the right the employer has, if ultimately we've given the opportunity for the healthcare provider to complete the paperwork, we've followed up, we still don't have the information that we need, the employer can send you for an independent medical examination at the employer's own cost. And of course, that examination would be limited to the underlying medical condition forming the basis for your request for accommodation. It's not a full-on physical. It's limited to the issue, but the employer does have that right when all else fails. So just some clarification on medical inquiries and exams. This comes up a lot. There is a big distinction between what is permissible before an offer of employment has been made and then after an employment offer has been made. So if you're in an interview, an employment offer has not yet been made, it is okay for the employer to review the job description with you and ask whether you can perform the essential job duties with or without accommodation. That's fine. An employer can also ask you to demonstrate your ability to perform certain tasks. I would imagine that being a greater issue when you're looking at physical disabilities. Demonstrate that you can lift you know, heavy UPS packages, for example. And that's okay. They can do that as well. An employer, though, cannot ask if you are disabled. They cannot ask the nature or the severity of your disability. They also cannot require a job applicant to take any sort of medical examination before the job offer is made. Now, once a job offer is made, an employer may make that contingent upon you completing a medical exam. That's permissible so long as the employer requires it of everyone coming into that position. You know, a great example, I'm just going to pick on our UPS package delivery folks. The UPS, and I don't know, UPS may require all of their delivery drivers to go through an exam. And that's not singling anybody out, but that's just our practice, and that's okay. There is an instance, it's called the direct threat, an instance in which an employer can target someone for an examination. And it's very specific circumstances. There must be a significant risk of substantial harm to the health or safety of either the individual, to coworkers, or to customers that you can't eliminate. When that happens, the employer has the right to send you for an independent medical examination. Where I have seen this come up most frequently is, unfortunately, there have been instances where employees have threatened suicide. And that's not something that we want to play around with. If you have threatened to harm yourself in any way, whether it was a joke or not, we're going to err on the side of caution. I have a lot of clients, when that happens, they're going to put you on leave, and they're going to send you for an independent medical examination to make sure you're okay. That's where you may see that come up, or you may see instances where someone is threatening violence. making threats in the workplace. Now, that's not to suggest that people who have mental illness are necessarily violent. The statistics actually show that many of the people who commit workplace violence do not suffer from mental illness. But still, as the employer, you also have an obligation to keep your employees safe. And that includes the individual who may be threatening to harm him or herself. That's a situation where it's legal for the employer to send the individual for an independent medical examination and potentially put you on leave until that we know that you're good to come back. So potential accommodations in the context of mental illness. Most of the time we are looking at some sort of flexibility or adjustment to attendance expectations or scheduling. It's going to be so dependent upon the type of work, but it may be a different shift change. You know, maybe medication that you take makes your tummy upset in the mornings and it's hard for you to get to work on time. But guess what? If we put you on the 11 a.m. shift, you're good. You know, that's okay. Same kind of notion about modifying the start or end times of the work. It could be something as simple as, you know, taking a shortened lunch at the employee's choosing, but so that I can have a later start time. Of course, like I said, telework has become a very popular request, and it is hard, you know, it is hard to know where that request is coming from. Some people just don't like other people, and that's not a disability, but some people just don't like other people, and they don't like to get dressed, and they don't like to come to work. And for those folks, there are jobs that are totally cool with you working from home all the time. But a lot of employers still really value the in-person collaboration. And I do. You know, our job is flexible. I can work at home some days, I can go in some days, but I like interacting with people. And for me, it's good for my mental health. If I'm always at home, I'm spinning in my own little cone of silence. It's helpful for me to go to work. But telework is a potential accommodation that could be effective, and many employers are open to that now. Post-COVID, we know it can work. Of course, permitting more frequent breaks. It doesn't always work to have someone on a defined break schedule. You have to take your break at 10 and 2. Now, some jobs, you have to. It's an assembly line. We can't have you walking off the line, you know, and all the boxes start accumulating because you've walked off. But other jobs, it doesn't matter so much so long as you take your break and having that flexibility. A lot of the accommodations are considering the working environment itself. A lot of folks benefit from minimized distractions, whether that's some sort of white noise or being allowed to listen to music, or I personally like the spa music. I'll kind of zone out to that when I'm working. And you may notice a lot of employers, they're rethinking their buildings. Like, this room is really dark. I like sunlight, and a lot of employers are trying to create working environments that allow in natural sunlight, and that I know it sounds, but having plants, having kind of decompress areas on your break. You can go sit over here and just kind of chill out for a bit. All of these things enhance the working environment, which makes it easier for folks who are dealing with mental illness. Modification of job duties is usually one of the bigger areas that we're focused on, and so there are some things that are reasonable, and you know, an employer would be expected to provide a reasonable accommodation, and then there are other request accommodations that are unreasonable, and the law would not expect an employer to do that. A lot of the focus is on the essential job duty. Why are you there, right? So if I have a receptionist who asks to work from home, that's not going to work. Like, you're there to greet the people. Or a bank teller, you're there to take the money. That's your reason. That's the reason for your job. We can't eliminate that. Well, I go back to let's say my receptionist. Maybe a small function of her job is she goes downstairs to get the mail. But she experiences anxiety about interacting with the evil postman. I say that my son, he likes to say that he dresses like an evil postman. I don't know what that means. But if my receptionist had anxiety about interacting with the evil postman, well, that's not an essential job duty. We can ask someone else to do that. So that's kind of the difference as essential job duties versus non-essential. A lot of it may relate to additional training, providing additional resources for an individual to be able to absorb the training. We all learn a little bit differently. Some things that are not reasonable is creating a new job. Now, you might be offered the opportunity to be reassigned to a vacant job, but an employer is not expected to create a job. It's also not going to be an excuse for misconduct. So again, that's why I say if you think you may need an accommodation, it really behooves you to make that request up front, because it could impact your work performance, or it could result in some conduct in the workplace that causes discipline, and then to say after the fact, oh, well, it was because of this or that, that's hard for the employer to understand. So you always want to be proactive in that regard, because ultimately an employer can and will enforce its policies regarding performance and conduct. We get this one sometimes about an employee may feel very stressed at a particular supervisor. The law is not yet that broad to permit individuals to request a new supervisor because of a stress. And again, that's just part of the reality that not everybody likes each other. And that's just part of interacting with humans. Sometimes we just don't like each other. So who pays for the accommodation? It is the employer's obligation to pay for the accommodation. Now, if you want a particular accommodation, and the employer says, well, this one's equally effective, it's cheaper, I want this one over here, they have to offer you the opportunity to be able to pay the difference, right? Or to pay for the accommodation that you want. Now, that might not be feasible economically, but that is something that's out there. So if you're in that situation and you want a particular accommodation, you can offer to pay for that so that you have the accommodation of your choice, assuming the employer agrees. Leave of absence as an accommodation. So again, y'all got lucky with me. I just took a leave of absence. So after my panic attack and going to the Fifth Circuit, I talked to my boss, and I've been a lawyer for 18 years. I've been with the firm for 13 years, and I was still very bashful about putting my hand up and saying I needed some time. For me, it was difficult to admit that I was not as strong as I thought I was. And despite my tenure and all of those things, I was still very nervous about talking to my boss about it. But I said, I've got a lot going on right now. I'm not my best. My son is struggling. I'm struggling. I need some time. And she wholeheartedly supported it. She said, you need to take some time. And so I did. I just took, it was, I guess I was still kind of working part-time, but I took like 4 weeks. And I'm a whole different person today than I was when I was flying to New Orleans at the 1st of June. I knew that I was on the brink of making a mistake. And, as a lawyer, you make a mistake, you're getting sued for malpractice. You don't want to do that. So that 4 weeks of taking some time for myself, and I'm in a whole different place. I feel ready to be at work and to do my job and to focus on what I need to do. So leave of absence may be the accommodation that you're requesting. And that could be a continuous leave of absence, or it could be an intermittent leave of absence, where you may need to just work kind of reduced hours. Now, there are generally two kinds of leaves that you may be considering. There is leave of absence as an accommodation under the ADA, but you may also qualify under the Family Medical Leave Act for leave under that particular statute. So both may be kind of coming into play. I will say, of course, the leave is unpaid generally, unless you have accrued PTO or you have a serious health condition that would qualify for short-term disability benefits, assuming that you have such a plan. But it is unpaid. You have to pick what's best for you, I think. So the FMLA, what is the FMLA? I think too often people think of it as just maternity leave. It's so much broader than that. Of course, it only applies to employers that have 50 or more employees. So your smaller employers are not expected to offer FMLA. As an individual, you must have worked for the company for at least 12 months. You must have worked at least 1,250 hours in the preceding year. And you must work at a job site where there's at least 50 employees within a 75-mile radius. Now, the qualifying reasons, again, they're a lot broader than just maternity leave. It's your own serious health condition, which mental illness would qualify. But it could also be the serious health condition of your family member, of your child, of your spouse, of your mom. So FMLA is a little bit broader in that regard if you need to take some time off to take care of a family member. Now, under the FMLA, you're entitled to up to 12 weeks of continuous leave or 480 hours of intermittent leave per 1 year period. Now, in the FMLA context, similar to the accommodation process, there is a healthcare provider certification form that has to be completed and returned to the employer. Doctors are very familiar with those. They are a form from the Department of Labor. They've seen those before. So what are the differences between the ADA and the FMLA? You have the size difference, right? So the ADA applies to employers that have at least 15 employees, where the FMLA, you have to have at least 50 employees. So there could be a difference there. A waiting period. Under the ADA, technically there's no minimum length of employment that you need before you get an accommodation. Under the FMLA, again, you have to have been there the 12 months and worked the 1,250 hours. Maximum period of leave. This is an area where the ADA is a little bit more flexible. So the FMLA is very defined. You get 12 weeks or 480 hours. That's it. A lot of times, people will be on FMLA and they run out of the 12 weeks. It's just not enough. Well, then the ADA kicks in, and that's where an employer might offer you an additional month. If we give the employee an additional month, they'll be able to come back. And so the ADA is actually a little bit broader in terms of how much time you might be able to take off. Now, restoration to your job. Under the FMLA, the employer has to put you back in the exact same job. Your desk, your chair, it's sitting there empty the whole time you're gone. You come back, there it is. Under the ADA, technically the employer should. But if it becomes an undue hardship to keep your position open, they can fill it. Now, what that means is when you're released to return to work, the employer should work with you to find another vacant position. But there is kind of an exception there in that, you know, the employer doesn't have to keep your job open if they really are able to show the undue hardship they need to fill the position. Now, coverage. Under the ADA, employers are only required to accommodate employees. There's no obligation to accommodate family members. It's just the employees. But under the FMLA, again, you can take FMLA because of the serious health condition of a family member. So in that regard, you have that protection there if it's really someone in your family that's struggling and that needs some help. Reassignment is another possible accommodation, and we call this the accommodation of last resort. Candidly, a lot of employers forget about this. They go through the interactive process. They decide that there's no accommodation that they can offer that doesn't cause an undue hardship or that allows you to perform the essential job duties. And sometimes employers, not meaning any harm, but sometimes they forget about reassignment before they move to termination. Reassignment is the last resort. Okay, do we have a vacant position available for which the individual qualifies that we could put them in? Now, you have to qualify for the position, and it has to be vacant. So again, the employer's not obligated to create a position. They're not obligated to bump someone else from their existing position. It has to be available, and you have to qualify. But that is an option. And so is there another position available that I could perform? Unfortunately, it may be at a lower rate of pay, and sometimes that happens. Like, this is the only other position we have available. You could totally do it. We can accommodate you in this position, but it is at a lower rate of pay. That's legal. They don't have to increase the rate of pay. Because then that would be a little bit unfair for the people who are already in that job earning a little bit lower rate of pay. So that's something to keep in mind. Ideally, the position should be equivalent, but it doesn't always work out that way. And ultimately, I think it's better than losing your job. Something is better than nothing, and it keeps you employed. An important note regarding confidentiality, because I think, again, there's still a lot of stigma with this, and we don't necessarily want everyone in the world knowing about our issues. The ADA does require confidentiality. It's not HIPAA. HIPAA applies to healthcare providers, but the ADA requires employers to keep medical information confidential and separate from the personnel file. So and it's like a need to know thing. So probably human resources is going to know about it because they're the ones that are usually facilitating the process. And there's probably going to have to be limited disclosure to supervisors. Now, supervisors don't need to know the exact nature of your condition, but certainly they need to know, for example, that you're now going to be working a different schedule. So there is some, need to know basis, but it is required that there be confidentiality, and it's certainly not permitted to openly discuss an employee's medical condition with others who don't need to know. That would violate the law. So building awareness and supportive culture. Where I work, I love my firm. We have affinity groups for those that have disabilities of any kind. We have mental health awareness webinars, mindfulness, how do we practice mindfulness? We have all kinds of things that are designed to provide resources to us to bring awareness and to eliminate the stigma. And when you think about the types of people like that I started with on the first slide, incredibly talented people, what a shame if we wouldn't have benefited from them because they didn't have the opportunities and they didn't have the culture needed for success. I'm going to shut up at this point because one of my very dear coworkers, Kelly Hughes, she agreed to include a video for us to watch. She suffers from OCD. And she has been with our firm for, more than 20 years. She is a success story. And I wish she could have been here in person, but she's dealing with a flare-up right now. And her traveling is difficult for her right now. But she wanted to share her story with you. And then also here are some ideas in terms of being a supportive supervisor. Or, if you are in a supervisory role or you kind of educate or mentor supervisors, these are some simple things that can make a very big difference in the healthiness of that relationship and in the productivity of that relationship. So without further ado, here is my good friend Kelly Hughes.
Hi, everybody. My name is Kelly Hughes, and I'm a shareholder in the Charlotte office of Ogletree Deakins. And my dear friend and colleague, Tiffany Stacy, has asked if I would be willing to share a little bit about my struggles in various areas of mental health. So just a little bit of background I think might be somewhat relevant. I grew up in Georgia and would consider myself to be a very type A, high achiever. I had a very loving family, very, very conservative, and definitely very strict, but I always felt secure and loved. I would say I was an anxious child, but didn't have any kind of obsessions, compulsions, or anything that I thought was out of the ordinary, at least at that time. So I went to college and then to law school and joined the Ogletree firm and started working. And in 2006, I had my first baby, a girl. And in 2009, I had my second child, a little boy named William. And when he was about a year old, I was working a lot of hours and I was giving a presentation about 2 or 3 hours away from Charlotte. And I was speaking, and in the middle of my presentation, all of a sudden, I felt this whoosh of panic, and I felt very, very dizzy, and I lost my train of thought. Now, I actually continued to present. I think I was speaking on wage and hour issues, and I continued to present, but I just felt absolutely off. Finished my presentation, and I got back in my car, and I immediately started to catastrophize. I thought, oh my gosh, what just happened to me? What happened? I mean, thank goodness I was able to continue speaking, but what if I had fainted? Oh my gosh, if I can't present, then I may lose my job, and oh my gosh, if I'm going to lose my job, then my husband may leave me, and then oh my gosh, he'll take the children, and then I won't have my children, and oh my gosh, what if something happened to my children? And then the thought popped into my head, another what if was, oh my gosh, what if I lost control and I hurt my baby? Specifically, I was scared to death that I could smother my then 1-year-old son. When that thought popped into my head, I lost it. I started hysterically crying. I thought, oh my gosh, what is wrong with me? There is something horrifically wrong. Do I have psychosis? Do I need to go and check myself into a mental hospital? I had no idea what was happening. So I got to my house. I told my husband what was going on, and he said, oh, you're just sleep deprived. This is probably because you stopped nursing our son cold turkey. You probably shouldn't have done that. Maybe your hormones are out of whack. You just need to get some sleep. I said, no, I am scared to death that I am going to hurt William. I can't go near him. I stayed up all night, would not sleep because I was scared that if I was left alone that I could hurt my baby. My husband woke up the next morning, realized that I hadn't slept, and said, okay, well, I'm going to go to work. I said, do you understand what I'm telling you? I am scared to death to be alone. I had this awful thought. What if I lose control? And what if I smother William? And he said, well, I'm willing to take that risk. You're going to need to take the kids to daycare, and I need to go to work. I think that you just need to rest. And so I took the kids to school. I was shaking and crying the whole time, scared that I could lose control. And then I ended up going to the child's pediatrician's office. My son's pediatrician's office has a lactation consultant. And I happened to be pretty close friends with her. And I said, I do not know what is going on. There is something really, really wrong. And I explained what had happened and the progression of my thoughts. And I said, oh my gosh, I had this thought that I could smother William. And do I have psychosis? Do I need to be committed? Do I need to, go to the ER? What should I do? And she said, oh, actually, Kelly, what you're describing is very, very common for new moms, common for women who have, just either had a baby or at some time in the postpartum. So she said, I think you actually may have obsessive compulsive disorder because it sounds like you're having intrusive thoughts. And I said, that's ridiculous. My mother has OCD. I'm very familiar with OCD. It's contamination. This is something horrific, and there is something wrong with me. So long story short, which has already been too long, I know, I went to multiple psychiatrists, multiple psychologists. I took myself to the leading experts in the country in various regions regarding obsessive compulsive disorder to meet with them to explain what had happened, what my fears were. And it was very, very paralyzing. I thought my life was over, and I just kept thinking, oh my gosh, this is horrific. And does anybody hear me? I don't have OCD. I know what OCD is, and this isn't it. And finally, after hearing the same diagnosis, that actually, yes, Kelly, what you have are intrusive thoughts. Everybody has intrusive thoughts, but some people who have stickier brains, like I do, tend to get stuck on that thought, and they ruminate and think, why would I have that thought? Why would I be worried? Why would that pop into my head? Does that mean I'm a bad person? And reading into the content of those thoughts. So thank goodness I had a lot of support and access to care. I finally conceded that perhaps I did have OCD, which my version at the time is called pure O. So where I don't have any outward compulsions, I just have the ruminations. So I will say that part of my treatment, I started taking a medication. I also started doing cognitive behavioral therapy, primarily exposure and response prevention, writing worry scripts to affirmatively state my biggest fear and to kind of sensitize or desensitize myself to those fears. So over the years, my OCD has waxed and waned. During, I actually had a third child, and my OCD had calmed down before then. And as soon as I gave birth to my third baby, I started having those same intrusive thoughts regarding harming that child. And then when I was able to go back on my medication and revamp with my therapy, things got more steady. But I will tell you, it has been quite a struggle. It has morphed for me. I think some folks with OCD, they tend to stay in similar areas. Mine has morphed from being scared that I was going to harm my children to a hyper awareness of my body parts. For a while, I was hyper aware of my nose, just the existence of my nose, and my catastrophic thinking progression would be, oh my gosh, I see my nose in my peripheral vision. What if I never stop thinking about my nose? What if I can't focus on my work? Or what if I then lose my job? Then if my husband leaves me and then he takes the children, etc. So it can be, it can really go from different topic to topic. And most recently, it shifted to existential worries. So in the fall of 2022, this past year, I had a very, very significant flare-up to where I needed to take a leave of absence. So my firm, thank goodness, is incredibly supportive. So I wanted to kind of point out a couple of different things about what has been critical for me and the path that I've taken. I was able to take a leave of absence, get very, very intensive therapy, work on some medication tweaks, and I have been back slowly ramping up and have been back at work practicing law for several months now, and things are going very well. It is something that I have to manage every day. I will probably be taking medication forever. I will probably be in having therapy, regular therapy sessions, and really, really working every day. But what I think has been critical to, frankly, to my survival, number one is to know that I am not alone. And if you have anything even close to what I have, you are not alone. There is always somebody that is suffering very, very similarly to you. And that, just knowing that I wasn't the only one going through this and was able to get connected to others as well as to very, very helpful resources was invaluable. But if you happen to be an employer, just know that you are likely, it is very, very likely that you have some individuals in your employee population who struggle with things like OCD, or it could be generalized anxiety disorder, depression, and things of that nature. And I think it is absolutely critical to show, honestly, to show love, support, grace, and help develop empathy. Of course, you want to comply with the law, comply with the ADA, and any type of state state or local laws that impact where you are and where you work, but really having that level of support and compassion from my colleagues during my leave and after my leave has been absolutely invaluable, and I will never forget it. So I feel free to reach out to me if you need any kind of support whatsoever. I'd be happy to share the resources. I read everything, and I would be happy to share the resources that have been really personally helpful for me, of course. So blessings to everybody. Thank you.
Thank y'all. Sorry for going over a little bit.
Thank you again, Tiffany. I know we're kind of a little, 2-3 minutes over our time, but if anybody has any questions, we can probably take 1 or 2. Yes, ma'am.
I just have a question for like the ADA and FMLA. Do you have to like disclose like the exact conditions or you have to
So as far as what you disclose to your employer in making the request for the accommodation, I don't think you don't have to disclose it. Now, a particular